The first matter to come before the court this morning is State of Ohio versus Casey Clelland. Mr. Kudici, the state has waived oral argument this morning. You have 15 minutes to argue. We've read the briefs. We are ready to see who you are.
Thank you, Your Honor. I appreciate that. Yes, so I won't be reserving any rebuttal time.
Unless you're going to argue against yourself.
And what's that?
Go ahead.
As facetious as that may be, you know, the government's absence on this case is notable to me. May it please the court, I am Richard Kudici. I am court-appointed counsel in this matter. Your Honors, can you sit in the sun on a beautiful summer day, on a Saturday afternoon in the United States of America without police intervention? The reason I came here today, as mundane as this may seem, it is a very important case. You know, consensual encounter these days are seen on TV, not daily, weekly, where police have interaction with folks, things go awry, and you wonder, why is this officer talking to this person? You have a unique opportunity in this case to talk about some refinements as to what consensual encounter may mean, because that's what the state of Ohio characterizes this case as being. But I also ask you to take a look at what does impliedly coercive mean. The trial court's findings below relative to this denial of the motion to suppress, Your Honors, is not supported by competent and credible evidence. The lower court erred, particularly because this is not a consensual encounter case with Casey. Casey said no when he wasn't asked a question, and the police continued to...
Counsel, you say it's not a consensual encounter. When did it stop being legitimate? The officers noticed that he was sitting there for approximately 45 minutes, and then they went up to him, and as I understand the fact, the patrol car was close to him, or how far away, or I don't have a mental picture of that. But you're not contending that simply going up to him in the patrol car was improper, are you?
Well, let's talk about legal issues and the legal definitions. No, I'd say you're right, Your Honor. Judge Whitmore,
so you say it became improper at what factual point?
Well, let's take a look at the facts real clearly, because Casey is sitting on at North High School, you know, a school where in days before we probably all played at the school ground or sat on the school, on a Sunday, Saturday afternoon. It was a beautiful day. The police think 45 minutes sitting there is something suspicious. Now, the answer to your question is this, starting with the predicate of how Officer Smith talks about his consensual encounter. He says, well, there's something unusual about sitting there for 45 minutes. He says, well, I wanted to do a field investigation. He says, I wanted to investigate this matter. All of a sudden, we have a police officer with thinking about how to investigate. So the answer to your question is this. If a police goes up to you and say, hey, how you doing? Now, let's talk about why did this police officer stop there? He said he was concerned about Casey. And so the answer precisely to your question, Judge Whitmore, it began when Casey said, when the police officer said, hey, what's going on here? Are you okay? And Casey said, yes, I'm okay.
I'm waiting for a ride.
I'm all right. I'm waiting for a ride. That's
where we start to have difficulty in terms of the legitimacy of the ongoing relationship or conduct of the police towards your client.
Absolutely. I'm going to develop that a little further here, because that question of sitting there, first of all, becomes no criminal behavior. There's nothing articulable relative to criminal behavior. But if you look at the standard, the judge...
Let me stop you there. So the next thing, as I understand it factually, is that the officer asked, what is your name?
Yes.
Was he permitted to do that?
Sure, why not?
Okay.
I mean, we may have all experienced that. I know I have.
And when once the officer asked him, I think the testimony at the hearing was that your client hesitated before giving his name.
Which he can do. So are we going to now translate that, parlay that into probable cause or particular?
No, I think that the issue then is you take it step by step. if the officer asks your name and you hesitate, then the officer testified that it was the hesitation that made him somewhat suspicious. I don't think the state is contending that that established probable cause. It was just, okay, well, how do you spell it?
Mm-hmm.
Is that problematic?
Well, let me develop that as well. First of all, if a police officer comes up to me and says, "What's your name?" and I say, "None of your business," then where are we at? What if I hesitate and say, "You know, I would never say that, by the way, because I would be respectful to a police officer, but I might say, you know, officer, I'd rather not have a conversation with you because I'm a lawyer and I know what to do." Now, Casey might have hesitated for a second, "Well, what's going on here?" But then, Judge, what happens is he gives a spelling of his name, and what does the police officer say? "Well, wait a minute, that's not how you spell your name." Now, how would he know that?
Well, was there testimony, is the record going to show that at the time that he gave the initial spelling, that the officer or one of the officers was entering that into the computer?
Well, I don't know what they were doing other than the fact that the police officer very clearly, this is very critical here, the police officer clearly testified he was investigating my client. This was not a consensual encounter, it was an investigatory stop. And when the lower court said the police officer wanted to check on the situation, and Casey said, "I'm okay, I'm waiting for a ride," the officer doesn't stop there. He keeps developing an investigation. "What's your name?" "Whoa, what's your social security number?" Now this is very critical, Your Honors. When that question was asked, what did Casey say? "Why are you asking me that question?"
Which he's permitted to do.
He is.
But the officer then asked, "Well, do you have warrants?"
No, that's not what happened, Judge, and I would ask you to clearly look at this transcript. What Casey then said, when he said, "Will you give me your social security number?" Casey said no. So now all of a sudden are you okay? "Yes, I have a right." Then the next thing we're asking, "Do you have any warrants?" We're moving into investigation. If I may get to that, the critical distinction on the abuse of discretion here, I ask you to look at because there's no support to this. And when you look at the initial stop, this was a stop, Your Honors. There is no question about that. State v. Bobo clearly identified. My client's doing something, all of a sudden the police comes, he's stopped.
Again, let me stop you there. Did your client ever simply make a gesture that he was going to get up and walk away?
Well,
Or did he just sit there and submit to whatever questions the officers posed?
Well, first of all, I caution the court with the characterization that the government makes on this matter when they like to conveniently call this a consensual encounter. But
Mine was just a specific question as to the facts. Did at any time he get up from the rail and make any effort to walk away from the...
he did. He got up and ran away, and he was tackled and put in custody.
That was later on.
It was.
Okay.
But so let's take a look at the whole picture of consensual encounter. Are you free to go? Now, can you refuse to answer? Can you say no? In this instance here, it's like this, my client's sitting here in a guardrail, the police officer's cruiser comes up right here, they're in full uniform, there's a gun on them, there's two officers. That is impliedly coercive at the start. Now, if I may get to some other matters, such as the notion of having two uniformed officers, being in a confined area, that is not an easy situation to put yourself in. You have the notion that legal authority is here and you have to answer it. Now, more importantly as well, when you scrutinize that, Your Honor, let's take a look at the questions. You have a seamless onset of questions. What's your name? How do you spell it? What's your social security number? Is that the correct number? Are you sick? Are you okay? Do you have any warrants? It is critical when you look at the nature of these questions, it is a seamless inquiry that has gone by these officers. And the distinction on that comes, what would you think would happen if he walked away or if he said no? Or, I mean, you know, I've been there, we've been there, the police officers don't like that. But if you are looking at this matter and identify this as a consensual encounter that requires certain standards to apply, then you cannot find that the lower court correctly denied this motion to suppress because there's no articulable suspicion. There's no evidence crime is afoot. There's no evidence that crime is being committed. So if you take this as a consensual encounter, you have to look at the notion of free to leave. Now, if I can address a case that is of critical importance here, and also, as I'm running out of time here, I ask you to take a look at the record, read through it, how this officer very clearly said. He testified at that point with my experience when people start, acting confused and giving me, names after hesitation. Come on, what is suspicious about that? You hesitate about giving your name? Well, I would think that would be something that would be normal with people. In my experience, a lot of times they have warrants, and this officer was very candid to say he was investigating Casey for something unbeknownst, but something he wanted to find out, just in case. And that's an investigatory stop, and you need articulable suspicion. Let me get to one other case of Supreme Court of Ohio. State v. Robinette, 80 Ohio State 3rd, 234, Your Honors. In that case, very clearly, Robinette was seen speeding. The officer stopped him. The officer had intent to just give him a warning. So he got out of the car, asked Mr. Robinette out of the car. I said, look, I'm just going to give you a warning. Everything was fine and dandy. After returning his license to Robinette, the officer said, oh, one other question. By the way, are you carrying any illegal contraband, weapons, drugs, anything like that? Well, Robinette said no. But Robinette said...
Excuse me. I don't see Robinette cited anywhere in your brief.
It is not stated in my brief, Your Honor, but the principles, if you don't want to utilize that because I did not update that, the principles in Robinette are that once he said no, Robinette said, well, I was shocked. I said, and the police officer wanted to search me, and I just automatically said yes. Just like in this case. Casey was asked a question, do you have any warrants? And you go, well, maybe, I think so, and so the court considered that in Robinette, whether the detention after Robinette was initially stopped or Casey was initially stopped, nothing was found out that seemed like criminal behavior. That's ended. The court said if during initial detention to ask about contraband questioning, the officer ascertained reasonably articulable facts giving rise to a suspicion, then the officer can detain him further. But the court said here, as in Robinette, the court said officer did not have any reasonable articular fact or individualized suspicion to justify Casey's further detention. And if you look at the totality of the circumstances here, armed uniformed police officers, boxed in, 2 officers, continued questioning, seamless questioning, you have, as the Supreme Court said in Robinette, when they considered the totality of the circumstances there, the court held the officer's questioning of Robinette was impliedly coercive. And that's exactly what happens in these type of quote-unquote consensual encounters where there's seamless questioning in a short period of time. That's what happened to Casey. And so the reasoning here is the transition between the detention and the consensual encounter had been so seamless that Robinette had been coerced into answering the questions that he was not required to answer. And look at the statute 2141, where it talks about the requirement to give identification here. So this is exactly the case here. There's no dispatch filed about a suspicious person, about an identification, no crime afoot. The officer wants to do an investigation on this field investigation of my client. Let me conclude by saying on transcript at page 17 and 18 gives the actual conversation between the client and my cross-examination. But, Your Honors, no reasonable person in a case like this is going to think they're free to leave. And no person like a young man of 19 years who's sitting at a parking lot when a cruiser pulls up is going to think he's, not under scrutiny. There's coercive, certainly coercive authority there. And so the court erred. It didn't have competent evidence. The court below did not say anything, Your Honors, about my client saying no. That's a critical determination in the court's decision. And The lower court also admitted the officer's admission of being an investigation, that he was investigating my client. So, there was no criminal behavior here whatsoever. This case, it's just wrong what happened here. And I ask you, I leave you this. Can a person sit in a schoolyard on a beautiful Saturday afternoon in June in the United States of America? And the answer is, of course they can, in this court right here. Your Honors, you must affirm that principle in America.
Counsel, regretfully, I need to inform you that you've utilized your 15 minutes worth of time. Thank you.
I appreciate your attention. If there are no further questions, then thank you very much.
Thank you.
Yes.
The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website.
Yes, Your Honor, and have a great day, and thank you for your kind attention. I appreciate the fact that you have clearly read my brief.